Before we begin the arguments for this morning, I'd like to inform the members of the bar of a very unique initiative of the Supreme Court. We have prepared a handbook on combating gender stereotypes to assist judges and the legal community in identifying, understanding, and combating stereotypes about women in legal discourse. It contains a glossary of gender unjust terms and suggests alternative words or phrases which may be used while drafting pleadings as well as orders and judgments. So it reaches out to lawyers as well as judges. The handbook identifies common stereotypes about women, many of which have been utilized by courts in the past, and demonstrates why they are inaccurate and how they may distort the application of the law. The intention is not to criticize or cast doubt on past judgments, but merely to show how stereotypes may unwittingly be employed. To raise awareness against the utilization of harmful stereotypes, particularly those prejudicial to women, the handbook aims to explain what stereotypes are and helps judges identify and avoid such stereotypes by, firstly, identifying language that promotes gender stereotypes and offering alternative words and phrases. Two, identifying common reasoning patterns that are based on gender stereotypes, particularly about women, and discussing why they are incorrect. And three, highlighting binding decisions of the Supreme Court of India that have rejected these stereotypes and can be utilized by judges to dispel gender stereotypes. So it's been, you have the first page of the document here on the screen, and it's uploaded. It will be uploaded very shortly in a minute or two on the website of the Supreme Court of India. We have also uploaded on the website right now the manual and FAQs for e-filing. And in a couple of days, we'll be also uploading simple video tutorials on how to do e-filing for members of the bar who just require a little bit of hand-holding on that. So that's all. It should be here on the website in a minute now, or a few minutes. Thank you. Thank you, Dr. Krishna. Yes. No, but Mr. Dwivedi, if you start using it, you'll find it so simple actually.
But now you find hampered because of the because certain things that have come up, I feel you're not having adequately.
Please do answer them in your submissions. No difficulty.
It requires addition.
No, addition you know. So we are making notes, so you can always make the addition in your oral arguments. Mr. Mr. Dwivedi, I'll give you a concrete example. I'm in the process of sort of formulating a judgment. We are still, now it's almost done, on Hindu law as to whether a child born from a voidable marriage is entitled to a share in the ancestral property. So today, over the last few days, I've opened the file. We didn't have any such limit as we have now imposed here. 3 or 4 written submissions by each member of the bar, 3 or 4 compilations by each member of the bar. It's impossible to sit down to dictate a judgment because, you have judgments of different genres in different submissions coming up, and it becomes impossible for the judges to write judgments. So today in the morning, I was telling my secretary, I said, we first need to now look at all the judgments, prepare a separate file, put them in chronological order. But even then, it doesn't help because you have marked what was being read out by the lawyer. So, this is the real problem which we face.
There are 2 issues. Judicial precedents were never in such large volumes as it is available today. Go back 10 years even. Number 2, the concept of giving written synopsis was comparatively not there. Everything used to be argued. We used to take down notes and dictate. Now, the purpose of a submission or a synopsis, as I understand, is to facilitate in dictating the judgment. Instead of that, it becomes so much more cumbersome that we don't know who is saying what, where. These kind of pleadings of thousands of pages used to not be filed. So that's, there are many cases of this category. No. At rethinking, they are certain.
Trivedi, my take on this has been, if the homework in the office is thoroughly done, normally this problem doesn't arise.
Can never be complete.
It is possible to do.
The judgment can never be complete. The judgment can never be complete. That thought process will continue from your
And
side,
you know that-
it will continue from our side.
My fear always as a judge is that in this process, I've missed out some very important point of judgment because it's all, sort of placed in different silos. That's what is really worrying for us as judges. This about reading, trying and collating can always do that. Can tell our law clerks to put all the judgments together in a chronological order. Danger is you feel that, oh my God, I might have just missed something because things come in, driblets over a period of time. Supreme Court gives 30 minutes time and 1 hour's time. So we need to now just.
The US Supreme Court do it in 30 minutes. The most complicated case, they only hear you for 30 minutes, including time interventions of the court.
No, we are far more advanced technologically. Actually, trust me, we are almost at the high end of the curve in India.
Part of habit action.
Yes. So that we can just keep it on the dais, as the hearing. That will be very useful. Naika Bhushan. Yes, that you want to refer to. And again, refer to. That's very useful. Oh, you have also put it in a plastic. Oh, excellent. Yes, Dr. Lala.
No library talk this time, my lord. But start again, my lord. I appear for the JK People's Conference, my lord, in writ petition 1165 of 2019. A question that your lordship put to Mr. Sibal was, have you challenged the presidential proclamation of 19th December? We've challenged the suspension, my lord, and that is very important to our argument on Article 3. There is also another petition, my lord, Sohail Qureshi 1068 of 2019, which actually challenges the proclamation.
2068, right?
1068.
Yes.
Now, my lords, I would begin by saying, as well from my lord the Chief Justice, that this oral submission is in the nature of a dialogue, and a very important dialogue, which even the US Supreme Court doesn't have. They assume everything is read and there's a bit of question and answer and that's it. And it is because of the nature of the dialogue, we have to, on an ongoing basis, answer what fell from your lordships as well. I'll give your lordships an example. My lord, the Chief Justice made a reference to 249 and 252. Of course, they are of a different genre. But nevertheless, my lord, that question is very, very important for us to build the diversity argument and whether there is transformative constitutionalism, whether there is a basic structure, whether that's a lost cause or not. Then, my lord, your lordships had asked questions about Article 3(1)(d) and whether Article 370 subclause 3 survives. Now, this is important because it's been used only twice. It was used in GO 44, my lord, and now it has been used once again in GO 273. Now, if it doesn't survive, my lord, how can it be used in this particular way? We have to answer that question for your lordships. In addition to that, my lord, there seems to have been some confusion or misunderstanding on the status of merger agreements.
Check.
The question that fell from your lordships was that once the instrument of accession is over, sovereignty is
Hello,
complete.
check 1, 2.
Our respectful submission, my lord, on this, which I will elaborate. I've done it in a note, my lord. Like Mr. Zafar, I'll hand over that note, my lord, to your lordships. My lord, 3.7, as far as the instrument of accession is concerned, it deals with external sovereignty. Kindly bear this in mind, it's very important. External sovereignty
Hello,
is
hello,
lost.
check 1, 2.
With a few exceptions here and there. But internal sovereignty is not lost. That is why in Premchand, they say the monarch was still an absolute monarch. Premnath calls for him. So, what the purpose of the standstill agreement was, what system would you have in the meanwhile? The state of the Raja of J&K didn't sign a standstill. The records show there was some toing and froing and eventually, which means he retained all his power. So as far as internal sovereignty is concerned, the standstill was very important because all the powers of the Maharajas and the coming states, my lord, retained their internal sovereignty. Now come to the merger agreement. The merger agreement is important, my lord, because it finally indicates the extent of internal sovereignty. If there was no standstill agreement, and if there was no merger agreement, my lord, the Maharaja would be absolute, as Premnath Kaul says. So I take 370 to be, my lord, a substitute, a constitutional substitute for a standstill and merger agreement, without which, my lord, we are lost. And I'll explore that, my lord, later when I come to 370. Your lordship also, my lord, put a question to Mr. Zafar Shah that on the 4th of August, what were the autonomies that you were going to lose? He promised you a list, my lord. One answer to that is everything, but I will indicate what these autonomies meant and what was lost for Jammu and Kashmir, which comes back to Justice Kaul's question, are we flogging a dead horse? The answer is no, my lord. It continues and it has to continue to preserve, my lord, the federation and the conditions under which the federation was created. So let me begin with what I began with the other day, my lord, and that is that we have the greatest diversity in the world. Take many continents together, take many countries. This diversity is unparalleled. That is why, my lord, Professor Ravinder Kumar, I asked him, I said, what should I say in my Colombo lecture? He said, say that the Constitution of India is a constitution for a civilization with many nations and many cultures. And this is what makes our Constitution more exciting than any other. On the question of diversity, I was taking your lordships to, where is my other note? Right, one I was just reading it. I've, my lord, done a list which I'll give to your lordships, my lord, but I was going to invite your lordship's attention to Article 3 first. all of Article 3, my lord. But I'm going to read one important aspect of it, my lord. And that is the proviso which says that before anything is done under Article 3, it is mandatory for the president to refer the bill to the legislature. Mandatory. It's a condition precedent before you invoke Article 3. Just as there are conditions in Article 370, which have to be fulfilled by condition precedents. Now, on Article 3, my lord, the proclamation of 19th December virtually created an amendment of Article 3 by taking the condition precedent out. Mr. Sibal read all that to you, but I want to refer your lordships, my lord, to that particular part of the proclamation. My copy, somewhere here. Your lordships will find this, my lord. Like Mr. Dwivedi, I have no problem with what your lordship is doing. We just have to learn and catch up, my lord. This your lordships will find in volume 3 documents.
Page 92.
And the PDF, my lord, I'll just give it to your lordships.
Page 92.
PDF 92. Now, my lords, I want to take your lordships straight away, and it's very important that we should.
Sanjay Miller. Page. Ultimately, everything boils down to this. Of course, the Constitution itself, and but so far as documents are concerned, in one page now we have. In case something is missed, you can tell Mr. Dr. Dhawan's instructing advocate. They'll just put it in and what do we call this? This plastic made up.
Not-
So, kya bolte?
Divine fire.
Plastic made out, so kya?
Your Lordship will see that there is a condition precedent in Article 3. And this condition precedent, my Lord, was added to by CO 48, which I'll show to your Lordships in a moment, my Lord. Which further required the bill to be sent to the legislature of the state, but we're not concerned with that because it has to be sent to every single state. Now, my Lord, I take your Lordships to this notification C subclause 2. So much of the first proviso of Article 3 of the Constitution as relates to the reference by the President to the legislature of the state, and the second proviso to that article, so that much of clause 2 of 151, which is about audits, my Lord, of the Constitution as relates to laying before the legislature of the state of the report submitted by the governor to the Comptroller Auditor General. You will see that the opening sentence is the following provisions are suspended. In other words, my Lord, a mandatory provision of Article 3, whether it applies to Kashmir or elsewhere, my Lord, is suspended. It's not a question of just laying before Parliament as a substitute. Article 3 and Article 370 does not tolerate substitutes. Now, my Lord, what does this do? This is not, my Lord, that can be done under a proclamation under 356. It is a constitutional amendment which is subversive of the Constitution itself. If this suspension fails, my Lord, President's rule will fail. And its extension, my Lord, in July will also fail. You have amended the Constitution, albeit to all states and certainly to Jammu and Kashmir. And this mandatory provision takes us to the core of the mandatory requirements, my Lord, of Article 3. Because the entire JK or Reorganization Act emanates from Article 3 and Article 4. Take away this condition, my Lord.
How do we deal with this Article 356(1)(c)?
Sorry, my Lord.
Article 356(1)(c) says that if he may make a proclamation where a situation has arisen that the government cannot be carried on in accordance with the provisions of this Constitution in any state, and then C.
Make such incidental and consequential provisions as appear to the President to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operation of any provision of this Constitution relating to any body or authority.
So the President has a power to suspend certain provisions of the Constitution during the operation of a proclamation under 356.
The suspension in this case goes beyond supplement, my Lord. It goes to actually taking out a mandatory provision. It was not eaten into my time.
Absolutely not. 255.
No, my Lord. There's Mr. Dinesh Dwivedi's time, my Lord. He took my time. Of course, my Lord, Article 4 says that I did on libraries. All that has to be adjusted. Will be treated as I'll do my best as not requiring an amendment. But leave that aside. But what I've done now, my Lord, as I put summaries 3 and 4 to operate, which I'll hand over like Mr. Zafar Shahade. But what I can't resist, my Lord, on the diversity argument, a passage from TMA Pi, which is not in your Lordship's compilation. So I've made copies. May I hand them over? The presidential duty, my Lord, has to be a little more careful. Because this was tailored way back in 19th December 2018 to start a process, my lord. Lord, I'll take your
Of amending the
straight away
constitution
for the
to para
purposes of which,
157, which is on page 586.
Normally when the legislature, here, of course, it's the constitution,
And just
uses
below,
the expression means and
Placetam
includes.
D.
Yeah, it's not means, but it says make and includes. When means and
this is
includes
the
is
most
used by the
evocative
legislature, it's an
understanding
indication
of the diversity of our
expanding the
constitution.
power.
Apart from the
So,
two Delhi
when the
judgments,
Constitution says,
which
begin
went
by
into it
saying
in
make
depth.
incidental or supplementary provisions,
Yes.
and then says
Now, just below
including.
Placetam
So
D,
this
Lord,
including
may I just
seems to
read?
be to widen the ambit of what was stated
All
earlier.
the people
In
of
the
India are
earlier
not
part
alike.
says you will make only.
And
you
that
will
is
make
why
incidental or
preferential treatment to a
supplementary
special
provisions.
section of society is
But
not
then it
frowned
says
upon.
including.
Article 30 is a
So
special right
including would
conferred
mean
on the religious
that
and
what was
linguistic
otherwise
minorities
not a
because of their
supplemental
numerical
or
handicap
incidental
and to
provision
instill in them a
is
sense
within
of
the ambit of
security
the
and
presidential
confidence,
proclamation,
even though
isn't
the
it?
minorities cannot per
Because
se
suppose the
be regarded
clause
as
C read
weaker sections or
just up to
underprivileged
proclamation
sections.
and didn't
Now,
have
158
and
is
including.
the evocative
It's
passage
not
that
and
I want to
including, it's
read.
including.
That's right.
Suppose
The
it's
1
ending with the
billion
word
population of
proclamation.
India
The operation of
consisting
any
of six
provisions of this
So
main
if the
ethnic
last
groups,
part of
52
Article
major
356
tribes,
1C was not
6
there,
major religions,
you could have challenged any amendment of the
6,400
Constitution on the
castes
ground
and
that
subcastes,
you don't
18
have the
major
power to
languages,
make an amendment
and
of the Constitution
1,600
in the
minor
guise of
languages
making
and
incidental
dialects.
or supplemental
The
provisions.
essence of
This is the
secularism
basis
can
of our
best be
challenge,
depicted if a
In our
relief map
petition,
of
we have
India is
challenged
made
only
in
the
mosaic,
suspension.
where
My
the
question is
aforesaid
this,
1 billion
suppose
people
the President
are
in
the
a
small pieces
proclamation
of marble
suspends
that
the
go into the
operation of
making
any
of the
provision
map.
of the Constitution.
Each
Is
person,
that
whatever
amenable
his,
to a
her
challenge on the
language,
ground that
caste,
it is not
religion,
incidental or
has his or her
supplementary?
individual
Or
identity,
are these
which has to
words
be
of
preserved. So that when pieced
widening
together,
the ambit
it
of the
goes to
first
form
part
a
of 356
depiction
1B? So
with
as
the
to be immune
different
from such a
geographical
challenge.
This
features of
law has
India.
remained within
These
the
small
limits
pieces
of
of marble
356.
in the
That is
form
for
of
the
human
governor, you read
beings,
the president, for the
which
legislature,
may be
you read the
individually be
legislature.
dissimilar to
But I've never seen a provision in any
when placed
proclamation, my
together
lord,
in a systematic manner, produce
throughout
the beautiful
my
map
lord,
of
these
India.
decades.
Each
which
piece,
actually
like a
uses
citizen
the
of India, plays an
supplemental and
important part in the
including.
making of the whole.
I've never
The
seen it take
variations of
away
the color
a
as well as the
mandatory
different
provision of the
shades
Constitution.
of the same color in a map are the result of these small pieces
This is
of
exceptional.
different shades.
Now you can read it
and
together
colours,
in one
but
way, you can
even
read it together in the other way.
When one small
If you
piece of marble
expand-
is removed, the whole map of India would be scarred. and the beauty lost.
356C,
Just
Lord.
over the page, my lord.
Then you will say that the president has a carte blanche
Each of the people
to
of
amend
India has
any
an
part of the
important place in the
constitution as part
formation
of
of
the
a nation.
supplementary provision.
Each piece has to
Can you, for
retain its
example,
color.
say that there'll
By
be no
itself,
judiciary
it
in
may
that
be an
state?
That's right, Lord.
insignificant stone. But when
what
placed
you're
in a
That may be
proper
covered by the
manner,
proviso, but
going
then
into the
right.
making
Oh,
of a
yes, the
full
proviso
picture
said, of course.
of India
Supplementally,
in all
this
its different colors and hues.
356C
A citizen
has
of
to be
India
read
stands
with
in
the
a similar
mandatory
position.
provisions which it
The
cannot
Constitution
dilute.
recognizes the differences amongst the people of India, but it gives equal importance to each of them, their differences notwithstanding. For only then can there be a unified secular
But
nation.
actually the proviso,
Recognizing the need for the preservation
Dr.
and
Gavan, the
retention
proviso
of different pieces that go
seems
into the
to
making of the
indicate
nation.
if
The Constitution,
Parliament,
while
if the
maintaining
Constitution
inter alia the
wanted to
basic principles of
exclude a
equality,
particular power
contain adequate
from
provisions
the
that
authority to
ensure the
suspend the
preservation
provision
of
of the
these different
Constitution,
pieces.
then that
I wanted
has
to
been
read this, my lord. It's a very
specifically,
evocative
defined.
passage, my lord.
So the proviso says that you will not suspend anything pertaining to a high
No, my
court,
lord.
or you will not assume to yourself as the president any of the powers which are vested by the Constitution in a high court.
Yes.
Your lordship
During
will be
the
dealing with pieces of
operation
marble,
a
my lord.
proclamation under Article
How you deal with
356.
it, my lord.
So where it wanted
come
to
later.
introduce a restraint on the
Now,
presidential
my lord, may I
power,
invite my
it has done
lords,
so
my
in the
lord, to
form
my
of the proviso.
submissions. Right.
Do we now say that,
Yes.
well, apart from the proviso, there may be
Which is in
certain other
volume
parts
1,
of the
page
Constitution which the
195.
president cannot suspend?
PDF 195.
Or would that be reading into Article 356?
I'm going
words
to
which
go
are
at
not
super
there?
speed, my lord. Lord,
Just one. I
because
think
there's a guillotine on my head.
coupled with the words appears to the president to be
Very
necessary
sharp
or
one, I might
desirable
add.
for giving effect to the
No, my
objects
lord.
of the proclamation.
Yes.
So
I
they have
just
to
take
be
your
connected
lordship
in a
very
nexus
quickly.
with the object of enforcing the
Come to the
proclamation.
198. my
That's a
lord,
restriction.
Page.
It must
The
relate
external,
to
your lordship's
356.
page. Skip all that, my lord.
In other words, whatever
And come
is
to page
required to
200,
materialize
which is
356,
page-
it must be related to that.
Which file are you?
Volume 1. And therefore, my lord, these words,
Conditions, my lord.
necessary or desirable, are not carte
WC.
blanche powers of the president. Could he have, under these provisions, suspended part 3?
Yes, yes. Yes.
It has been done, my lord.
Part 3?
That fundamental rights,
Volume 1 and the rest.
directive principles.
Right.
Could he have done all that, my lord? I'm sorry, my lord. Therefore, my lord, it has to be given even with the caveat of regards the High Court. It has to be
your
given a
page
limited meaning
195.
where your lordship finds where it starts, my lord, that in
195 to
every
288.
state that has
Index
been
which I won't
created
trouble
under
your
Article
lordships with,
3
my
and
lord.
4, this has been treated as a mandate.
Volume 2.
But I'll take volume 1.
Volume 1.
There is a
Volume 2 was
caveat
the
that your
civil
lordship
submission,
has imposed.
which came, my lord, a few days late.
On Article 3 and 4, that all that it requires is a reference to the
volume 1 पे है.
legislature, and the union is not bound by it. Those, my lord, when I do come to my written submissions, I'll run through them very fast because I don't need to, my lord, take out the books or refer to the cases. This, to my mind, my lord, taints the entire process. But at 200. Your lordships have it, my lord?
Yes.
Yes.
I'm taking your lordships on PDF 200 in para 1.5, because all the other documents have been read. I'm not going to repeat them. The history has been shown to your lordships. But I made a point, my lord, about why the merger agreement was important and why 370 in one sense represents the standstill and merger agreements. I'm going to read this passage, my lord, from Premnath Kaur in para 1.5. Has your lordship got it?
Yes.
Referring to the past, my lord, thus there can be no doubt that this act of 1939 marked the second step taken by
On
the
the
Highness
inclusion
in
provision for
associating its subjects
suspending
with the
in whole or in
administration of
part
the
the
state.
operation
It
of
did
any
not
provisions of this
constitute even a
constitution
partial surrender
relating
of
to
His
any
Highness
body
or
of his
authority
sovereign
of the
rights
state.
in favor of the Rajya Sabha.
Even after the instrument of accession, my lord,
And then a
he
quote.
had not given up his rights. This further subscribes
That your lordship will come over the page.
the extent of. I
The
can get the
presidential
PDF numbers
proclamation.
to this if your lordship wants, my lord, but it's.
Otherwise,
No,
my
we
lord,
got it.
356 is an
Now, my lord,
exception dealing with, it overrides after the
federalism.
instrument of
How
accession.
many judges was Premnath call?
It collapses democracy in a state.
Right.
No, it's. Yes, 5 judges. These are all constitution benches. Now, my lord, may I take your lordships to 1.7?
This is in relationship, in regard to the relationship of the Maharaja with the Praja Sabha.
This is Praja Sabha. my
Praja
lord.
Sabha.
I'm now building on that, my lord.
Yes.
Therefore, my lord, what actually 370 represents is two powerful democratic movements, my lord. One in the people of India, my lord, and the other, my lord, in the people of Kashmir, demanding of their Maharaja, which is eventually what he did. He gave a Praj Sabha, he wanted a national assembly, but he didn't agree to a constituent assembly, which came later, my lord. Now, my lord, 1.7. Maharaja Hari Singh continued to be the absolute monarch of the state, and in the eyes of international law, he might conceivably have claimed the status of a sovereign and independent state. Because all the instrument of accession did is put in these 4 conditions and said externally, my lord. That's why I made the
Because if the
distinction
presidential
between
proclamation
external sovereignty
does something
and
that is
internal sovereignty.
irreversible.
This is with reference to
That is a test your lordship will
August
use.
1947, not with reference to the
I'm coming, my lord, to the instrument of accession, my lord.
adding? Because I think we were reading Mr. Sibal's list of days, there's no innuendo in any of the.
Four
lists,
zero
so
six.
just state the date. So if you feel that, there's something missed out, then you
PDF
can make
1-3.
track changes in that list of dates, so it'll be a little
1-3.
easier for us, ultimately.
Same
after.
volume. Ultimately, it isn't.
Same volume.
My lord, what I'm endeavoring to do, my lord, this is the substance to the list of.
All right,
dates.
fair
This
enough.
is what I'm trying to
Fair,
do.
fair.
My lord, in a sense,
Not
the
just reading it
54
as a
order.
list of dates.
Fair.
Now,
And
1.370,
375,
my lord, represents the constitution as relates to Kashmir. They were brought in by the
1.25,
Constitution on the 17th of October 1956. The Constitution of Jammu and Kashmir was adopted by the JK Assembly.
they will be excised.
Sir, that's what I went to him and told him that your whispers are also being recorded.
My lord, we will deal with all that, my lord,
शाम को बोले और निकाल लें.
with a pinch of salt, my lord.
But it's quite accurate, huh?
I shudder to think, my lord, if this was the case when we were arguing Babri Masjid, what would come in the transcript? Because a huge amount of exchange took place, my lord. Now, my lords, therefore, my lord, how do you amend the 370? You amend it through the 368 process. But there was in CO 48, my lord, a provision that you will then go to 370 and follow the procedure in 371. And that's very important, my lord. Your lordship asked, what was lost on the 4th of August? This is something that was lost. And they didn't even use the amendment power, which is the only power available to them, my lord, to delete 370. Not the circuitous process that they used in 272 and 273.
Yes, that's right.
Now, my lords, on 235, 11.32 onwards. My lord, your lordship conferred, that took time as well. Happy though I am that your lordships did, my lord. My lord, I'm going to be super quick, my lord. Just give me that indulgence. Now, my lord, here are all the cases. Your lordship needs to go through Premnath's call, which I've summarized, my lord, in 11.3. Because it actually explains what the situation was after 1950. When there was an instrument of accession but no merger agreement. On page 236, my lord, my submission, my lord, from Premnath call is application of 370 of the Constitution to the state of JK also does not impact the plenary powers of the Maharaja. The form of the Constitution to be applied to JK was a matter left to be determined by the State Constituent Assembly, and until such decision was taken, the constitutional relationship between the Union and the state was governed by the terms of the IUA. So the internal, my lord, relationship had to still be determined under 370. Now, my lord, an argument has been made on the basis of Quran al-Kampal, etc. What is the meaning of modification? And they say it's very wide. But, my lord, your lordship has to read it in context. And that is when the matter was not referred to the 7-judge bench, my lord. Your lordship took the view that please read these decisions in context. Don't read them outside the context. Now, my lord, I'll come to 370, my lord. What I've done in the meanwhile, my lord, is done a short page and a half, my lord. But I'm not giving it now because your lordship may introduce the guillotine earlier. Now, my lord, kindly come to 370.
Does that begin at 239, Dr. Dhawan?
Sorry, my lord.
Is that? Oh, sorry. I thought you were referring to your submission.
My lord, I'm not going to repeat what's in the submission. I'm going to just, my lord, stress what is not in the submission, which I've stressed orally.
Fair. Yes, Doctor.
Now, my lord, we need not be troubled with temporary provisions at all. That has been the great, my lord, call. This is a temporary provision. It's temporary to the extent Article 3 is a consultative power to express views.
Steps
Article
that were
54
required.
is the right to
And I'm
vote
saying
in
that this,
presidential
in fact,
elections.
is in a
JK
sense,
was
my
not
lord,
able to
the merger
participate, my
agreement
lord, in
is
the
really
last
what three
presidential
seventy
election.
is.
Article 80 is to elect members to the
No, no,
Rajya
no.
Sabha.
I
What
take
do-
your lordship's page 515,
Article
96.
169 is to pass a resolution
which
for the
volume?
creation of
Volume,
legislative
volume
councils in a state.
thank colleagues that you have really summarized very precisely all that you have argued. You've taken down what you've argued, but now this is
Let me
formulated.
read it out, my lord.
Certainly, certainly.
And then I'll sit down. If so, my lord, that's a problem. It undermines not just federalism,
Article
but
370.
democracy itself. So I've said all the materials, my lord.
Article 370 can be amended, subject to the caveat in CO 48 that all amendments relating to JK must follow the procedure in Article 370. It is not enough in
been withdrawn. There was no material whatsoever. The
That's
only
not
material with
279A,
respects was
which is the GST
that
amendment.
the ruling party in its manifesto in
I put
2019
it
had said,
in summary
we will
form, my lord, in
abrogate
the
Article
table so that it will be
370.
a little easier for your lordships.
Your lordships in DC
Even in the
case have
distribution,
said
my lord, as
that
far
you
as the
cannot
GST applies,
exercise constitutional powers to achieve political ends.
279A subclause 4G
Lord, it's a classic case of fraud on constitution.
says special
So
provision.
Lord, you have a government.
I'm sorry, my
in
lord,
Lord,
where I put in my
association
chart,
with a local party in
279,
Jammu and
it should
Kashmir,
say
it is
279A.
working well. You suddenly withdraw the support from that government, then you persuade the governor to issue president to issue a 356 order, then you persuade president to issue a resolution of the
No, my
assembly.
lord, G is a very, 4G
You,
is a very
Parliament
interesting
then
province.
apparently
Special
takes control
provision
of
will be
legislative
made to
and
the states
executive
of
functions,
Arunachal,
and then you say,
Assam,
now president
Jammu and
will exercise
Kashmir,
all powers
Manipur,
into
Meghalaya,
one,
Mizoram,
and you
Nagaland,
pass orders
Sikkim,
under
Tripura,
370.
Himachal
Lord, what
Pradesh,
more
and Uttarakhand.
classic example of abuse of power than this can be? Lord, as Chief Justice Coke said, Lord, way back when the fight began with the king, that Lord, king can do everything except making a man a woman and a woman
Partly
a man.
that and partly because of the nature
Lord,
of the
surely
states.
president could not have, Lord, exercised this
But
power
this can be
under
reversed and it will
373,
be placed
assuming
before the
himself to be
GST.
everything.
Because it lays later on
What,
that
Lord,
the GST
Lord,
Council.
has been pointed out at great
We'll look
pains
then,
and
look
very
at this.
brilliantly that
Now,
Lord,
my lord, I come to
356
Article
is a
330.
temporary provision. Now, Lord, 356 being a temporary situation, can you take actions which are
Very important
permanent,
provision,
Lord,
my
or
lord.
permanency?
To say that
or
special
permanent in
provisions
nature.
can't be made in the constitution.
Forget
is
anything
anathema.
else. Because Lord 356 itself says that everything that you have done in the interregnum will come to an end.